Good evening, everyone. I hope all of you are doing good. We are again going to discuss the topic of compensation and the consequences related to breach of contract. We did our first part related to the series yesterday, wherein we discussed about the general and special damages covered under Section 73. Today, we'll be discussing about the remoteness and measure of damages. Now, why is this important? I'll first tell you about that. If you have not listened or if you have not heard any of my lectures so far, there are some available on YouTube. You can refer to those. I would request you to also refer to the first part of the video if you did not attend it yesterday. And it is important to understand the first part in consensus and in relationship with this particular lecture today, because we have to know what are damages and what are the consequences that are covered under the Indian Contract Act. So we'll be discussing, I'll just share my screen with you for you to see that what is the topic for today's discussion. Okay. The title itself, if you see, remoteness and measures of damages. So yesterday's class was related to the concept of damages in contract law. And today, what will be the extent of granting you damages if the party has actually committed a breach? How much of damage are you entitled to get? And this is where the intricacy starts, right? You can expect questions from this as well. We discussed a few questions from yesterday's topic in the class. Today also, we'll go in the same manner. We'll be discussing question. You will find the relevance of the topic, for which questions are asked from this particular concept. Now, before I start with telling you what are measures and remoteness, I'll just give you an illustration, okay? Now, this is some illustration which you may always remember because I am relating this with chia seeds. So if you see, there was a time when through Instagram and through other places, we got to know that chia seeds are very beneficial. Okay, so I have based this entire example on the chia seeds. So there are two parties. Okay, we have X and we have Y. They have already decided that I will be selling you, let's say, 30 kgs or 300 kgs of chia seeds. And I'll deliver you this in a period of time. Okay. Now, hypothetically, Y has delivered 200 kgs of chia seeds so far at the rate of 30 rupees per kg. Okay. And now when 100 kgs are still left, Y gets to know that the market price of chia seeds are going up. Okay. And he realizes that if I actually have to make extra profit, why don't I ask X to pay me extra amount of money? So he now writes a letter to X and says, for this 100 kgs, I will be giving you chia seeds, or I'll be delivering it only and only if you promise to pay me 50 rupees per kg. Okay. So this is different, right, from the initial contract that was entered into between X and Y. Now, when he does so, what will be the remedy available to X? What is the compensation that X can ask from Y in case of a situation like this? Okay, is there a breach? Yes, there has been a breach, right? He has not delivered the promised amount of chia seeds to the person. Now, in addition to this, we can also see that what will happen if X actually has to go and repurchase this 100 kgs of chia seeds from somebody else. Okay, there can be two cases. One is X doesn't buy the leftover 100 kgs of chia seeds from somebody else and keeps waiting and then goes and sues Y. This is first instance. The second instance can be that X actually has to now go and buy the chia seeds for 50 rupees kg from somebody else, a third person. So we see here when he has bought the chia seeds at a higher price, not 30, but rather 50 rupees. Okay. So a loss of 20 rupees has happened to X. But when he doesn't buy anything, can he still claim compensation from Y or not? This is an important aspect where students get confused. If you get a question of simply that X has bought 50 rupees kg chia seeds from somebody else, you will calculate and you will say that it can be market price minus contract price. So I'll continuously be referring these two terms with MP and CP. When I write MP, this is market price and CP is contract price. We will go and find out why this formula is written over here. But this is for us to understand the difference or the amount of remedy or the amount of damages that are supposed to be given to the aggrieved person by the wrongful party. So the discussion here starts with the first example, wherein if X has not repurchased chia seeds from somebody else, has he actually suffered any loss or not? This is the answer that we will try to find out in today's class. Okay, so that can be the first thing. Second other example, very important. If you were there in my yesterday's class, I hope you remember about the employer planning to gift pen drive to the employees. Okay, so again, similar example today. We say that there is an employer, okay, very nice employer, very benevolent employer. He thinks and he says that I want to entertain my employees. Okay, we have a fest coming up, and for this fest, I will now invite a band of musicians. So he enters into a contract with band of musicians. He also makes a payment to them for 40,000 of rupees. Okay. And on the date when the musicians were supposed to come and perform, they do not really turn up. They say that we can't come and we cannot do the performance of the contract. Now, in this situation, as compared to the last example, what is the difference that you can see? Is there any difference? In the first example of chia seeds, was it a commercial sort of a contract? Was it a contract of sale? Was it a contract where there could be loss of profit? If you remember, what is loss of profit? The profit that X was planning to make out of those chia seeds. He had planned to make pudding out of those chia seeds. So whatever loss of profit has happened can be seen in that particular first example. But if you see this set of example between the employer and the band of musicians, wherein they are not really getting benefited. This is for the happiness of their employees, for the enjoyment during the fest, or to upgrade the value of the fest. Here, you do not really see any such damages. So how will we actually give compensation to the employer from the band of musicians in this case of breach of contract? So this was the beginning introduction for you to think, for you to understand what is going to be the discussion for today's class. We will have different type of transaction. In your exam also, you will be asked question where the transaction is going to be different. Okay, what transaction am I talking about? The transaction can be a contract for business. Okay, it can be a contract for business. I'll give you example, builder's contract. Okay, then it can be a contract for simply making a sale, or it can be any other contract. So we have this division that we'll be covering in the class, but the transaction will also, change the measure of damages, and that is what you have to remember and stick to. Okay. So I hope that you're clear with the example. I'm not giving you an answer right now, right away, because I want you to think after we are done with the discussion as to what should be the answer of the first case. I have changed the fact of the case and I've used the term chia seeds, but it is rather something else. And this is from a given case law only, where part of the contract was performed and the rest was left over. And how do we find out the damages in that given situation? Okay. So we have to start with our discussion of remoteness and measurement of damages. Okay. Now, what have we written over here? After the damages are found to be not remote, you remember that when we were discussing in yesterday's class, I told you that it can be either in the usual nature of the transaction. When we speak about usual nature, what is that? When you already both the parties are aware as to what they are entering into, what they are actually committing to each other. That was the first aspect of it. The second was the special damages, where there are special consequences. You must give the special knowledge to the other person. So if you are aware that this is not too remote, how do you actually assess the compensation? Damages are compensatory in nature. Okay. I have a question to ask all of you. What do you find any difference between the term damage and compensation? Very lucidly, we interchangeably use these terms, right? We do not really get bothered. We do not feel that there is a distinction between damages and compensation. So if you are aware of the answer, and you must know of this answer, I saw one of the questions in the previous year question, which was only and only of 4 or 5 terms. It said, what is remedy? Now, if you're asked what is remedy, what are you going to write under that? Is it only consequences, section 73, 74, or are there any other set of remedies? Will you have to mention these 2 terms? Will you have to say that the idea is compensation here? Compensation can be done by way of damages and other ways. So that is why damages are of compensatory nature, by which we intend to restore the person to the same position. So how do we restore them will differ from the transaction. But we are intending that whatever losses happen to a person, we have to restore them. We have to take them back to the original position as if the contract has been performed. Okay. So the second example, the musician example that I gave you, the band that was invited, you have to take the employer back to the position as if the contract has been performed. If you simply catch this one particular sentence, you'll be able to find out the answer for that example. Okay. Now, what have we written? That damages are to be assessed on what date? On the date of breach of contract. Okay. So now that we are moving ahead, I would just take you to section 73 again, in case you have forgotten or you do not remember for yesterday's class. What is there present in section 73? It talks about consequences of the breach of contract that we discussed yesterday, right? So we discussed this part of the Contract Act, section 73, and this compensation has to be not too remote from the loss or the damage that has happened. And there is also one explanation that is so attached to this particular the provision that we have read so far. So in comparison and keeping this in mind, we see that the damages have to be assessed on the date of breach of the contract. And you will find this in so many illustrations mentioned in the act itself. Yesterday also I highlighted and told you that there are 18 illustrations. If you sit today, you open your Bare Act and you read these 18 illustrations thoroughly, I am telling you, you will get clarity with respect to this topic in a very good depth. Okay. I have used certain illustration in today's class also. We'll be discussing it in the context, but I'll just take you there. Now, let's say this is illustration D. Okay. What is written here? A contracts to buy B ship for 60,000 rupees. So A has contracted, he's a buyer. Okay. And B is the seller. Why am I writing buyer and seller today? Because I want you to know one thing, that the buyer, if the seller has broken the contract, okay, or if he commits breach of contract, what is the buyer supposed to do? Is he supposed to do repurchase? And if the buyer breaches the contract, is the seller supposed to resell the goods on that day itself or not? Okay, very important question that I told you in the first example also, in the chia seeds example. So A contracts to buy B ship for 60,000 rupees. Okay, this is the ship for 60,000 rupees, but breaks his promise. Now, who's broken the promise now? This is the person. Okay, the buyer breaks the promise. A must pay to B by way of compensation the excess, if any, of the contract price over the price which B can obtain the ship at the time of breach. Now, this, if you go and read it in one go, you may get confused. That is why we divide it and we try to understand. So what is the excess? We say, let's say that B had to now sell this. I'm giving you 2 examples, so please connect and understand this. Okay. B goes and sells this or resells this particular ship to C for 55,000. Okay. Or B does not resell. He doesn't resell it to anybody. He understands that the market price is going down for the ship. He doesn't resell it to anybody. But what is the market price for the ship today? The market price for the ship is 55,000. Okay. What is the compensation that B can expect from A? The answer is given in the illustration itself. It says the excess of the contract price. What was the contract price? 60,000. And over the price which B can obtain for the ship at the time of breach. So what is the market value at the time of breach, or what is the value that B can actually obtain for the selling of ship? That is 55,000. So how much compensation is he expected to get? That is 5,000. So in either of the case, the term used here is B can obtain for the ship. Okay, B, either he resells, or even if he doesn't resell, if he tries to resell, what is the amount that he will get today? He will obtain 55,000, which is 5,000 lesser than the promised amount. And that is how you can understand that repurchase or resale is not a mandatory condition. Now, how did we understand? Did we really need a case law to get this concept? Not at all. This is getting, you will get this clarity from reading of the illustration itself. That is why I will urge you to sit today, now that we are done with reading of section 73. By the end of the class, we'll be done with it. You read all the illustration and try to relate and write the case law in front of the illustration itself for you to remember what is the principle for that particular illustration. So that is how we have written here that the damages are to be ascertained on the date of breach of contract. Where is this coming from? You just read that illustration, that on the date of breach of contract, what was the amount of damage. Now I'll tell you one concept. I hope you know about it. If you're a law student, have you heard of the term equity? There's a very famous saying wherein we say that one who seeks equity must do equity. Correct? So we are expecting the same equity from you here also. You are a buyer, or you are a purchaser, or you're a seller, either of it. We expect you to do what? We expect you to do equity. That is why you have to immediately take an action, right? On the date of breach of contract. That is why we have an explanation. This is taking us to the explanation of section 73. What is this explanation? Let's go read, and then we come back and find out the two boxes. What are they actually trying to tell us? So section 73 explanation. It says, in estimating the loss or damage arising from the breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into account. So, sir, when you are trying to find out the damages that are supposed to be given, you have to see the conduct of not only the person who is done breach of the contract. You also have to see the conduct of the aggrieved person as to whether they employed and used the means that existed for remedying the inconvenience that has happened to them. So you did not get chia seeds. Okay, did you go and take chia seeds from seed, or were you just simply sitting and waiting for the prices to go up and then go and buy chia seeds? Even if you do so, if you're sitting and you're not buying chia seeds at that particular time and the price goes up to 100 rupees, can you later claim 100 rupees from the seller? No. Now, in that situation, we are going to assess the damages from the date of the breach of contract. That is why if the buyer makes the breach, the seller need not resell the goods. It will be decided on the date of the breach of contract itself. On the other side also, if the seller breaches the contract, the buyer doesn't have to repurchase the goods to claim damages. So this resell or repurchase is not a mandatory condition. We already have the first formula, that is that the damages will be ascertained on the date of the breach of contract. Any longer delay beyond this will be at the risk of whom? Will be at the risk of the plaintiff. The plaintiff can be buyer or it can be the seller. That is why we relate this with this particular maxim, that you have to seek equity. You want to save yourself, immediately take action. Otherwise, know that just because you are reaching to the court with an ulterior motive, with a vexatious motive, does not mean that you will get a remedy of that sort. Okay. So we have understood the first aspect for today's class discussion, that the amount gets frozen on the date of the breach of the contract itself, and both the parties must be doing rightful conduct. One who's seeking equity, one who's seeking remedy, must also understand the consequences of their wrongful act, and they must not contribute to the loss that has happened to them. Okay. Now, before we get into sale, business, and other transaction, as I told you, what are these three distinctions? I said that when you are trying to understand damages, how much damages, ma'am, if this is a business contract, and if this is a sale contract, or if this is a service contract, so those damages can be assessed on the ground of these three type of interest. Okay, these are not per se asked in your exam. So far, I did not see any question on this, but I believe if you write it in your answer, this is something that you have read. Okay, you may not use the same terminology, but if once I tell you the meaning of this, you will understand that you have read it. So try to use these terms in your answer. Okay, it will just add more quality to your answer. So what is performance interest, expectation interest, and reliance interest? We are saying that what interest of whom? Interest of the party who has been aggrieved. Okay, so aggrieved person's interest, that is the lens, from the lens of an aggrieved person. We are saying, what would he want? In certain situation, he would want performance of the contract, and when the court is granting you that remedy, that is called as performance interest. Okay, when you talk about expectation interest, what is this? When you want claim damages, you expected that you will make a profit of 5,000 from buying those chia seeds and making pudding out of it. So what is the expectation interest in that particular situation? And the third one is reliance interest, where you do not intend to, there is no financial loss that has happened to you, but you still relied on the other person. In that case, how much of the interest of this agreed person has happened because he relied on your performance? The musician example. So these can be different set of interests which can be categorized for us to know that remedies are of different nature under Indian Contract Act. It is either you want to seek performance, it is either that what you expected out of this transaction, some profit, some amount of money, some delivery of goods, whatever it may be, the expectation interest. And the third one is your interest when you relied on the other person and the performance or the promise of any particular nature. Okay, so these can be three categories which you can use when you're mentioning your answer, especially when you're talking about contract and when you're speaking about consequences of compensation. You can write down about this particular expectation interest. Now, the nature of your remedies or the nature of damages are going to be different. Let's try to understand in what all headings do we have. So first, I have categorized a business contract. When we do a business contract, our idea or our intention is different. Okay, then we move ahead and we speak about the second type of contract, that is the sale contract. When we enter into a sale transaction, the idea or intention may be something else. So accordingly, our remedy is also going to differ and change. Now, what is a business contract? Prime objective is to make profit out of it. When you enter into the contract, you know that there will be some profit. The profit may be known to you, unknown to you, but you understand that from this transaction, there will be some amount of profit that I can expect to receive. And if you have not provided a liquidated damage in your contract, liquidated damages are decided damages by the consensus of both the parties, right? So if you have not put the consequences, the loss of profit can be granted as damages. So in that case, because it is a business contract, both the parties who are aware that the opposite party is intending to make a profit out of this, and accordingly they will grant you what? they will grant you certain damages related to loss of profit. How much loss of profit has happened to this person? Let's grant them that particular profit. Okay, you will get more clarity once we discuss the case laws related to it. It is only the introductory part wherein we say that the primary idea, always remember, of a business contract is to make profit out of it. Okay, had it been a sale contract, which we are going to read later, it would it's much more easier in a sale contract to measure the damages, because the sale price is mostly quantified. You have decided this much amount of money and I'll be giving you this particular goods on this particular date. So the quantification in a sale contract is much more easier as compared to a business contract. That is why we make this two categorization, and the judgments also, you see, are different with regards to what should be the quantification or measure of damages in the two type of cases. Okay, so I hope this much is clear. What all have we covered so far? If I quickly revise with you, we refer to section 73. We got an idea that here today we are understanding that if the damages are not too remote, in that case, how are we supposed to assess the damages, right? Then we spoke about these different interests that you can mention and that you can remember with regards to the interest of the aggrieved party. And we also understood the very important essential first principle, that the damages are to be ascertained from the date of breach of contract and not at a later point of time. Okay, then we have segregated to set of transaction to simplify and to understand when the question of this sort comes, that whether it is a business contract or a sale contract. The idea of a business contract is always to make profit, wherein even though there is no sale price or quantification, we have to find it out with regards to how much profit the person would have made. Okay, now let's just get to the case law so that you get more clarity of it. So this is our first case law, wherein we speak about the contract that happens between this person and the state of Gujarat. Okay, this is a builder's contract. So a transaction or a contract was entered into between the two parties. He's a builder. It was for expansion of road. And it was decided, some amount of money was also decided between the party, that we will be paying you this much amount of money for this particular transaction. Now, when they started executing, when the builder started executing this particular contract, they were terminated. Okay, they were stopped in between and the contract was terminated. Now, what is the remedy that they can ask from this particular defend or from the state of Gujarat in the given situation? So what has happened? This is firstly that they started with the working of the promised obligation. They were stopped in between and the contract was terminated without any justifiable ground. Now, what should be the amount of compensation that we have to grant them in a situation like this? So the court here recognized and said that we can allow you what? Loss of profit. Okay, I'll take you to the case law. We will read the case law and we will understand the important aspect from the case law. Now, what are we doing? How are we studying? We first refer to the base document that we have. This is the PPT or the document that I'm referring to. This has content. Okay, and then we also move and refer to the judgment. We can't read the entire judgment, but we will refer to the important part from the judgment. You must grow the habit of reading these judgment. Why so? Because you understand that how the facts were different in this particular situation and how have the court interpreted the remedy in the given set of facts. That is how, if let's say from yesterday's discussion, you remember Hadley versus Baxendale, you will see a question very similar to talking about crankshaft, talking about millers taking the crankshaft to the other place, but you add certain, you change certain facts, so the answer will obviously change as well, right? So do not blindly just see a few words, catch and see that okay, you get happy, this is related to Hadley versus Baxendale and I've read it. You have to thoroughly read the facts and then decide. Okay, And for you to grow that habit, you must try to read the judgments also. I understand you have paucity of time, or you do not get to read 100 pages judgment. Try to read the important aspects from it, like I have highlighted here. You can understand it with me. The court held here in this given case, which we have just discussed, the case is about the builder's contract, wherein the contract was terminated in between, okay, without any justifiable ground. How do we assess the damages? The court here said that there shall be a reasonable expectation of profit implicit in a works contract, and its loss has to be compensated by way of damages. We are saying and we are acknowledging that when you enter into a contract of this sort, we understand and expect that there is a expectation of profit that is implicit in such a contract. Okay, even though you have not expressly told that I'm expecting to make 15%, 10% of profit out of this transaction, but it is impliedly available there, and that is how you also get entitled to claim those damages from the other party. Then, now, if it is a well established principle that the respondent was guilty of the breach of contract in as much as the rescission of the contract, okay, because the respondent rescinded the contract unjustifiably, the plaintiff contractor had executed a part of the work contract, and the contractor would be entitled to damages by way of loss of profit. So we are highlighting here and we are mentioning here that you will be entitled to what? To the damages of the loss of profit that has happened to you. So that is how the court decided in this first case, that in a business transaction, what is always there? There is a hope and expectation of making profit. Then we have the next case law of Dwarka Das versus State of MP. Again, very similar facts. The builder was, granted an opportunity that he can make a boys hostel in Ujjain, okay, and so around 2 lakh of rupees were also paid to him. He was continuously obstructed by the government engineer only, and that is how they were not able to fulfill and they were not able to build the entire hostel on time. The government sign the contract and terminates the contract with them. Again, what will be the assessment of damages in this given situation? So let's read the important part again from the judgment. The court here again highlighted that the measure of what will be the measure of profit? It would depend upon facts and circumstances of the case. As I just told you, that we will decide and we will find it out from the facts of the case, and there is always a reasonable expectation of profit that is implicit in a works contract. Okay, so here also the court acknowledged and the court granted them 10% of the amount of remedy. Okay, the actual profit that they would have made, uska unhone 10% they granted. In the previous case, 15% was granted on the basis of the principle that the Supreme Court had evolved. So this is how you find, and we conclude here that what is the actual profit that the person would have made out of this transaction had you not terminated it, okay, or if you would have not committed breach of contract, and that is how we conclude. The second is sale contract, where you are trying to sell something. As I told you, here you are selling, right? Buyer, seller, you do not have to repurchase, you do not have to resell. We have discussed this illustration. We will discuss the second illustration. These numbers D and H are the illustration from section 73 of the Indian Contract Act itself. Okay. So what is section H telling us here? A contracts to supply with B a certain quantity of iron at a fixed price, being higher price than that for which A could procure and deliver the iron. Okay. So let's say A is the seller. Who is he going to sell the iron here? He's going to sell the iron to B. And A is also procuring this iron from somebody. So let's name this third person as X. Let's say he is procured it for 20 rupees. He's selling it for 30 rupees. Correct? That is what is written here. Let's read it again now. We say A contracts to supply B with a certain quantity of iron at a fixed price, which is higher than that of which A could have procured and delivered the iron. Okay. B wrongfully refuses to receive the iron. Now B says, no, no, I don't want your iron. Now what is A going to do with this iron? So in that case, B must pay to A by way of compensation the difference. Difference of what? The contract price of the iron and the sum which A could have obtained and delivered it. So here, A is a person who is doing what? Who is buying and reselling it to B. So in this case, the compensation can be assessed. Is it important that A should have actually procured the iron? No, that is what is written here, that he could have obtained and delivered to it. So what is the loss, or what is the loss of profit that has happened in this given situation? Can you tell me? If you say there is X and he was supposed to get it for 20 rupees, he would have made a profit of how much? 30 minus 20, that is of 10 rupees. So can he get the compensation of this without him buying this particular iron from X? Yes, he can do so. That is what is this telling us, that it is not important for A to actually procure iron from X. That is not important. What is important is that how much loss of profit has actually happened, which he was expecting, or which is very much reasonably expected in a transaction like this by a seller or a buyer. Okay, so the illustration H is also important. Please remember that how I have written can obtain, could have obtained, you can highlight these points and accordingly read when you're referring to the illustration as well. Okay, so now we move to the next case law. Okay, now this is an old case law, and what has happened here, that there was, let's try to read the important essential part from the judgment itself. So there are again two parties. Both the parties have entered into a contract. Okay, so there is X and there is Y. Okay, and in this given situation, X was told that please give me a particular car. Okay, let's say we are taking a car in this example, and now when X promises to Y that I'll be selling you this car, he says, okay, I'll give you this, let's say 10 lakh of rupees. Now, Y does not accept the delivery of the car. If he does not accept the delivery of the car, X is left with the car. What is X going to do with this car? On the day of breach, what is the amount of this car? Let's say it is 8 lakh of rupees. Is X left at a particular loss? Yes. Now, X actually makes certain alteration in this car and he delivers it to a third person, C. Okay, C said that I do not want the car as it is. I would rather want you to make certain alterations in it and then I will accept the car from you. So in this situation, he actually makes all these changes in the car and he gets it delivered to C. Has there been any loss that has happened to him? Let's say he sells it at 10 lakh of rupees only. Now this gets complicated, right? If he would have sold it at 8 lakh of rupees, it would have been very easy for us to comprehend and to understand that the damage has been of 2 lakh of rupees. But the facts have changed. I tell you that he makes certain alterations. So the first important point is he has done certain alteration. Then there is a third party who has come into picture, who has shown interest, who has bought the car at the same price. Okay, at the same price. But in that given situation, will X be getting any compensation from Y or not? Okay, what do you think should happen here? So if we read the important part from the judgment, the court said that the small changes that happened, okay, they did in fact a small cost of adapt the frames in their hands and with fulfilled order of the customer. So the other customer got that particular machine or the car, whatever it may be, and with certain alteration, he is a new buyer that you got. But that was a reasonable mode of mitigating the damage. What was X trying to do in this given case? He was trying to mitigate the damage. The statutory duty that is there on X. Why am I calling it a statutory duty? because we refer to Indian Contract Act, we refer to the explanation, and it says that the aggrieved person also has a duty to act in a rightful manner. So he was trying to mitigate the damage when he reached to the third party C and said that, okay, please you buy the car and I will make the alteration for you. But had Y actually not violated the term of the contract, had they actually accepted the car, what would have happened? X would have made two profits out of this transaction. One profit by selling the car to Y, the other profit by making a new car with those alteration and giving it to the third party C. And that is how Y will be asked to pay compensation to X in this given situation. Okay. So what was X trying to do here? He was trying to be following a reasonable mode of mitigating the damages. But it by no means follow that the damages are confined to the cost, okay, or a trivial cost of adapting the machines to the need of the second customer. That does not mean Y here later comes and say, okay, you want damages, I will give you damages for the alteration that you did. Whatever alteration you had to do, I will pay you for that, but I am not going to pay you anything extra. The court interfere and the court says that you have to pay him what? You have to pay him for the loss of profit that has happened to him. He would have sold one car to you and the other car to the third person, right? So you can't just simply go away by paying minimal or meager amount of compensation to the person. So the fallacy of that is in supposing that the second customer was a substituted customer. You are misconstruing when you say that the second customer is a substituted customer. That had gone all well. The makers would not have had both customers, both the orders, or both the profits. But we do not follow that. We say that if they had been minded, they would have performed both the contracts and have made the profit on both the contracts, but for the breach by this particular milk company of their contract. So whenever you get a situation like this, do not think that only the change of the price of amount of money is what you have to remember. The primary rule is market price minus the contractual price, but there are intricacies like this also which you can expect in your exam being asked, and that is how you are supposed to answer. Okay, I hope this is clear. So we have read this important essential part also, wherein, see, even though the case is related to a sale transaction, this does not per se talk about mitigating the damages, but does it cover the conduct of the party? It does. So accordingly, be very mindful when you're writing your answer. If I have read in this judgment also, we are covering the concept of section 73 explanation, I will use this judgment because I've already learned it, right? From my exam perspective, I would rather use this also in my answer. But obviously, keeping the time limit in your mind when you are actually writing your answers. Okay. Now we go here and we say we have to find these two things. Okay. This is another case law. You can refer to the car example that I gave you is actually from this particular case law. What has happened here? This was a machine case law, very similar fact. This is a car case law, 3 parties where you are giving the product to a third person. It is not important that you are supposed to resell or repurchase the goods. But what is one important aspect from this judgment that I must tell you? That let's say the car example only, X was supposed to sell it to Y and he had to actually sell it to Z. So in this case, the supply of the car, what happened in this particular given situation is the court said that I will grant you loss of profit. Why? Because the supply of the car was too much. Okay, supply was higher than the demand in the given case law. So that is why he could have made 2 profits and let me grant you profit. Okay, but if I tell you that X had to sell the car to Y at 8 lakh of rupees, and if Y would have accepted, he would have sold the car to Y at 10 lakh of rupees. What will happen here now? How much compensation do you think he'll be entitled to? The facts are changed. I have changed the facts now. Okay, I say X was initially supposed to deliver the car to Y for 10 lakh of rupees, But because Y did not accept the delivery of the car, he sold the car to Z for 8 lakh of rupees. Okay. What is the amount of compensation that Y is expected to get in this case? Please write your answer in the chat box if you have understood the idea of section 73 that we have covered so far, okay, from whatever we have discussed so far. Okay. Now we have another case law. This is an Indian case law. That is why I've mentioned this also over here, similar to the other two cases that we have covered. We have other cases also that we have to finish. So I'm dropping this case law for you to read. Very important, essential case law, wherein there are two places, Kanpur and Calcutta, and how the damages will be assessed when one party fails to deliver the promised goods to the other person. Okay. So this is an Indian case which you can mention in your answer. Now, very briefly, we will touch on the concept of non-pecuniary losses as well. Non-pecuniary losses are what? When I talk about profit can be of 10 lakh of rupees or 10% of the actual profit. Or when I speak about market price minus contract price, you can find out it can be 5,000, 10,000, 5 lakh or whatever. These are all pecuniary damages. But if in a given case, I tell you that because of your breach of contract, mental agony has happened, or I have felt very distressed, okay? In all those cases, how do we assess damages or losses? You do not find it in any of the illustrations. So that is why you must just simply understand it from two case laws. I have covered two different case laws. One where we acknowledge and we say that you do not give non-pecuniary losses like this in a commercial contract. Okay, you want to go and say there's nervous shock or there is distress that has happened under law of torts, that is a different case. But when we're talking about non-pecuniary losses, the commercial cases do not generally accept and allow that. Contrary to this, there is one particular case law, landmark and important, wherein the court said that even in a commercial contract, we will allow you non-pecuniary losses provided the contract is of a particular purpose. What is the contract for? The contract is for leisure or the contract is for enjoyment. I'll tell you the facts and then you'll get clarity. Okay. So what are we discussing? Very briefly, we are touching on non-pecuniary losses. Why have we tried to exclude these non-pecuniary losses under Indian Contract Act? Is because it is very difficult to be assessed, right? And we are here talking and primarily covering the commercial transaction. The idea of giving compensation to you is on the basis of the profit that you are generating, on the basis of the the benefit that you're going to get in this from this particular commercial transaction. So if any mental agony, pain or something of that sort happens, what are we supposed to do in this given situation? So we have the next case law here, that is related to Ghaziabad Development Authority versus Union of India. Okay, I have mentioned this as the first case law. This particular development authority was issuing a lot of schemes, and people used to enroll for the scheme, and they started expecting the delivery of the possession of the house to be done. Okay, they invested money, they were expecting the delivery of the house to be done, but because it was not done, a lot of complaint reaches to the court, and that is when the court tried to find out that what is the amount of compensation that we are supposed to give in this given situation, in the given set of facts. So do we have to acknowledge mental agony, or do we have to award damages for that? The court here said they refuse to award damages for the injured feelings, okay? Not the injury with respect to loss of profit, but the injured feelings to a wrongfully dismissed employee, and confirm that the damages for anguish and vexation caused by breach of contract cannot be awarded in what contract? In ordinary commercial contract. So they have taken reference and they have taken help of another case law, wherein it is very simple that if you have a ordinary commercial contract, and you are expecting to get remedy for the anguish that has happened, the mental agony that has happened, that we do not acknowledge and that we do not grant you under this particular case. Okay, so here also the court did not allow, but the court carved out and acknowledged the exception which was given by the court in this case of Jarvis versus Swan Store Limited. Now, Jarvis finds out a brochure, an advertisement of this particular tour company, wherein they say that we conduct a lot of house parties in a particular property. So they give an advertisement wherein they mention that we have house party going on in this particular property and you can join us, and they tell them that we'll take you for skiing, we will take you for all different type of adventurous activities, a lot of people come and live with us, so a good opportunity for Jarvis to go and enjoy his break. So accordingly, he books for 2 weeks of period. Okay, 2 weeks for this particular scheme that was introduced by the defendants. Now, when he actually goes, he finds out that there was nothing of that sort. Whatever was promised was frivolous. Okay, so first, my question is not primarily related to this concept that we are studying right now. What do you think can be the remedy if something of this sort happens? You find an advertisement, you find that the advertisement is promising you a lot of things which does not really come true later. Do you have anything in the Indian jurisdiction which can grant you any aid, which can grant you any set of remedy? Okay, so if you can think of any other statute, any other provision from the Indian Contract Act, please write your answer in the chat box. Okay, anything that you can relate to this. So in this case, the court said that this is not a contract which is purely commercial in nature, and in such cases we will obviously acknowledge and give you remedy for the agony or the trauma that you had to go through. Okay, now in the last leg of today's class, we are going to discussing about we'll be discussing now about the mitigation of loss. Okay, we already touched on the concept of mitigation of loss, that you have to mitigate, you have to try to suppress the loss that has happened to you. Why has the loss happened to me? A entered into a contract with B has committed breach of contract. Who has faced the loss now? A. Okay, so when A is facing losses, what is he supposed to do? He is supposed to mitigate the loss, and this is what we have read is present under explanation of section 73, a statutory duty. Why a statutory duty? Because it is coming from the statute. So the person breaking the contract cannot be exposed to additional cost. Okay, so why is it important for A to mitigate? Because he will not be getting additional cost from the wrongdoer later for his own wrongful act, and he is expected to act as a reasonable man. So when we will meet in our classes, we will have one discussion on who is a reasonable prudent person. Because why is this discussion important? You see tort law cases, you see contract law cases, you see criminal law cases as well. You always come across this term, a reasonable prudent person would have exercised this much of private defense, or the reasonable prudent person would have done this in this given situation to mitigate the loss. So we must understand this, who is this reasonable prudent person, the fictitious person that keeps coming up in all the cases, all the discussions that we see. Okay, and he cannot claim damages due to his own neglect. So that is why plaintiff in a suit has to prove two things. Who is the plaintiff here? A is the person who's facing some losses because of the breach committed by B. So plaintiff in a suit has to prove two things. The alleged breach of contract, that sir, B has done what? B has committed breach of contract, and he also has to convince the court that I was good in my conduct. See, I did whatever best possible avenue possibility I had to mitigate the damages that are happened to me. Okay, let's try to understand it from two case laws. Very important case law, Paizu Limited versus Saunders, and then we also have the Nanjappa case law. What happened here? We have an employee. Okay, so Muthuswamy was an employee of Nanjappa. And employee where? Nanjappa had a shop. The shop was a silk shop. He was employed, and we will do cases also, we'll do questions also, which are very similar to the facts of what we have discussed so far. That is why I am covering these case laws, because you know, you just can't simply read section 73, the idea of it. You have to read the essential important landmark judgments and these set of case laws which are time and again asked in the exam. Okay, so this I am highlighting again, very important, because a question has come on the basis of the same. Termination of contract that we saw in our builder example, then this particular case law as to how you're supposed to mitigate the losses. And not just MCQ, subjective questions also, plenty of subjective questions from this topic. Okay, so Nanjappa had a shop. He employs this particular employee and says that, okay, you are free and you have to work with me for 5 years from 1962. Okay. So for 5 years, you are under the employment with me and you will be taking care, you will be a salesperson in my silk shop. And this is happening in Bangalore. Bengaluru now. So what happens after 2 years itself, he terminates the contract of Muthuswamy. Okay. So he terminates the contract. Nanjappa terminates the contract, doesn't give any notice, doesn't tell him anything. What do you think is expected of this particular employee to do? This employee goes to the court and says, sir, I want compensation for the left 3 years. Okay. He employed me. He promised me that he is going to keep me for 5 years. Now I want compensation for the left 3 years of profit that I was expected to earn. If I would have continued, I would have made certain profits, right? So you grant me all the profit. And accordingly, he reaches to the court for this remedy. The court stops him. First, before I get to the answer, just take a moment and think about this. Do you think that the entire profit should be granted? Because whatever cases we have done so far, we were looking at from the perspective of one party and deciding that, okay, loss of profit has happened and grant him loss of profit. But do you think there is any duty of this particular employee in this given case? Yes. Is there any duty? Yes. The statutory duty that we have discussed. The court says 3 years. What are you talking about? Are you not supposed to go and look for any other job opportunity? You are a salesperson. We have come across and we have found from the facts that you have worked in this field for a very long period of time. You have good hold and knowledge as to how to sell silk saris. And that is why if you go in an urban setup like Bengaluru and try to find a job, you will get it in at least 3 months. Okay, so we are not going to grant you 3 years of compensation for loss of profit. We expect you to mitigate your losses. You can't simply sit and come to the court and expect that without working for 3 years, you'll be given the compensation. But has this defendant done anything wrong? Yes, we are acknowledging that. And that is why we are going to tell him that please pay him how much of damages? The profit that this employee would have made for 3 months. So 3 months is something that the court have decided, keeping Bengaluru in mind, keeping his profile in mind. All these are question of facts, right? And that is how you decide and you write your answer. So in DJS, a question of this sort was asked, but they changed the fact at the end. They said that despite of his best effort, okay, here he did not prove any best effort, but the question that was asked said that despite of best efforts of the employee, he is not able to find any other job. Now, how will you assess damages in that given situation? So that is why very important to read the facts in its totality. Okay, so we have this case also over here. We'll just read the essential part. The ratio I have highlighted, the person who approaches the court shall take all reasonable steps to mitigate the losses consequent on the breach. Okay. The question as to whether the plaintiff has taken all reasonable steps to mitigate the loss on the breach of contract is a question of fact to be decided having regard to facts and circumstances of each cases. So even if your fact is not absolutely based on this case of Nanjappa, you can still mention and say that the court acknowledged that the facts may change the remedy here. Now, in the given situation, the plaintiff on his own showing has not taken any steps to mitigate the loss caused by the breach. He has been in service from several years. He has not at all made any effort to seek similar appointment, and therefore he has not discharged his statutory duty, and the court said that he'll only be entitled to damages equivalent to a period of 3 months. So the profit he would have earned in 3 months is only what we are going to allow to him. Now, very similar case, the next case also, the Paizo Limited Sonder case. I'll just very briefly cover it and then we come to the questions. Okay. What happened in this case? Again, we have Sonder Salidi, and she enters into a contract with Paizo. Okay. She says that I'm going to give you silk. The silk was supposed to be delivered in the duration of 10 months. Okay. In the coming 10 months, from January to September, I am going to deliver this silk in installments to you. And every time I deliver, what are you supposed to do? You are supposed to make the payment to me. This was decided between the two parties. The first lot was delivered and Paizo Limited does not make the payment. Okay, what did they do? They did not make the payment. Now, when they fail to make the payment, Saunders get very apprehensive. She feels that, okay, there is a possibility that later also they are not going to pay me. So I am not going to deliver the goods to them. She writes a letter on 16th of January itself. She says that if you want delivery of silk, please acknowledge and promise me that you will make the immediate payment in cash. Paizo realizes, they say that, okay, this is something new that you're now bringing to our attention and you want this to be done. They say, okay, we are not going to continue and we are not going to immediately pay you cash. We are going to stick to the original terms of the contract. Okay. So Saunders decides that she's not going to deliver silk to Paizo. Paizo after this goes in the market and tries to find out a substitute or similar quality of silk from the market. When they realize that the rate of silk has gone really up the sky, and that is why now they claim damages from Saunders. They say they realize that, okay, this is going to be a big blunder. We will have to incur a lot of amount of losses, and that is why they go to the court and say that Saunders should be making payment of compensation. Now, this is very similar to the old case wherein we expect Paizo also to do what? Paizo also to mitigate the loss. The reason I still decided to discuss this case law is because I want you to find out and read from Sale of Goods Act, okay, section 10, section 11 of the Sale of Goods Act, okay. Why is section 11 of Sale of Goods Act important here? You have to read when you are doing this case law. I am dropping a hint to you. They did what? They did not fulfill the payment of price, okay. So if you do not pay the price or if you do not pay the amount that you have promised, will this lead into breach of contract or not? Okay. Non-payment of the price, because Saunders felt that you did not pay me for the first lot. This is breach of contract by you. Okay. So is this really a breach of contract? You will get the answer when you refer to Sale of Goods Act section 11. So try to read that particular provision and see in the given set of facts who has actually committed the breach of contract. Was it Paizo but by not making the payment, or was it Saunders only who decided to not deliver the silk to Paizo, okay, or who decided to change the fact. When Paizo reaches to the court in the given case, the court again comes to the statutory duty of mitigating losses, and the court says here that please remember that you were supposed to, you understand that the price of silk has gone up so much. Why did you not stick to this new condition of paying by cash? Okay, you had to mitigate and you had to find the best option available to you. The best option was Saunders the offer of paying immediate cash and getting the delivery of silk. So conduct of equity was expected from Paizo Limited as well. Okay, so with this, we have covered the concept of mitigation of damages and the right of the party to subside or to suppress the damage that can happen to them and to do equity. Okay, now we have certain questions that I have mentioned over here. Let's try to read and find out whether what we have covered in today's class is going to be beneficial for you or not. Okay, so the idea of discussing these questions at the end, when I was teaching you, I was continuously telling you of what all questions I have seen so far related to each topic. But at the end, we do this exercise so that you recall and you understand that whatever I have studied today has been asked in different judiciary examination. Okay, so the first question is that the object of awarding damages of breach of contract is to put the injured party in the same position so far as money can do it, as if he had not been injured. Okay, so what are we talking about here? That what is the objective of awarding damages, and what have we actually found out, that how do we actually take the person to the same position? Is it by way of money? Can it be non-pecuniary losses also? That is something that you can think of. In the light of the above statement, explain the various kinds of damages that the court can award. Also explain the rules relating to the assessment of the damages. Okay, so these rules also, not just today's class, yesterday's class as well, because they are talking about various kind of damages and all rules that you can think of, not one rule per se. So accordingly, you can mention from yesterday's class as well as today's class the different rules that we have read to find or to assess the damages depending on the transaction or the nature of transaction. Okay, the next case, the next question is from 2019. Mr. P contracted with Mr. D in January 2019 to sell certain gold ornaments at the prevalent market price at the time of the contract. Okay, the prevalent market price. Secondly, what is the subject matter of the sale transaction here? It is gold ornament. We all know that the value of gold tends to change, right? Tends to shuffle. So accordingly, when you read these facts, you have to see, is it a business transaction? Is it a sale transaction? What is the subject matter? Is the price supposed to fluctuate? We refer to the Kofu's case yesterday, wherein we were discussing about sugar. The price of sugar is supposed to fluctuate, right? At the prevalent market price. So they have decided that we will be sticking to the prevalent market price of at the time of making the contract. And the ornaments were to be delivered and paid by 31st March 2019. The gold ornaments were rendered on the prescribed date, but Mr. D declined to take the delivery or to pay. So he declines now, and Mr. P is left with the ornaments. The said transaction would have realized 5 lakh rupees less than the price under the contract at the market price. Okay, if Mr. P now goes ahead and tries to sell this gold ornaments, he will get what? He will get 5 lakh rupees lesser than the contract price that was agreed between Mr. P and Mr. D. Mr. P sold the ornament after 31st August. The delivery was 31st March. Mr. P waits till 31st August 2019 when the market again starts rising, and he only realizes 3 lakhs lesser than the price under the contract. So the loss could have been of 5 lakh of rupees had he actually sold it at the date of breach. But because he was smart and he sells it later, he only had to face the losses of rupees 3 lakhs at a later price. Okay. Now, Mr. P sued Mr. D for the damages. D contends that he should only be paying 3 lakhs. Why do I pay you 5 lakh when you only got the loss of 3 lakhs here? You have to drop your answer and tell me, what is the amount of compensation that will be granted to Mr. P? Will it be 3 lakhs? Will it be 5 lakhs? Or does it have to be anything else? Okay. So I hope you are able to gather and able to understand that we have covered this set of questions in our today's discussion. Okay. The rule regarding a person's responsibility to mitigate his damage is not an absolute rule. Explaining the principle respond to the above statement, right? It is not an absolute rule. We also see the factual situation. As I told you, when we talk about Bengaluru, when we talk about your expertise, the question that has been asked, if there are facts which are actually pushing you, which are actually leading to your unemployment, can we put the entire burden on the aggrieved person itself? No, right? So you can understand and you can accordingly criticize that particular aspect. A and B entered into a contract under which A was to sell certain shares to B, delivered on or before 30th December 2012. The shares were offered. Again, the very similar to this previous question, okay? That they were offered, they tried to sell it, but they did not accept the delivery at that point of time. Again, there has been change from the market price at the date of breach versus the selling price later. I hope it will be a very simple answer for you, because we discussed this in the beginning of the class itself. So what will be the amount of compensation which existed at the date of breach, or which existed at the date when he actually sold the goods to in the market? Okay. So with this, I will now conclude today's class. Before we move ahead and before you all sign out, I'll just give you a brief of tomorrow's lecture, which is very important. Okay. We have covered more or less section 73 so far by discussing the rules and principles and the idea of damages. Okay. Wherein mostly the damages are what? Unliquidated in nature, where the parties have not decided the nature of damages. In tomorrow's class, a very good discussion on the concept of liquidated damages and penalty will happen. So we will discuss how these two transactions are different. I must tell you, this is very important and a very crucial area of questions are asked from this particular topic. So do join us tomorrow at the same time to cover section 74, covering the concept of liquidated damages and penalty. Thank you so much, all of you. I'll now look at the chat box and try to see if you have any questions. Okay, so you can leave your questions in the chat box and I'd be more than happy to answer it later also. And please revise, please write down the name of the case law, try to write summary of each case law and try to attempt questions so that you get clarity as to what you have studied is relevant in the context of the examination or not. Thank you so much, all of you.